object. That's what you normally hear from my next guest today. She's a lawyer and she deals with litigation and estates. Mari Botma, how are you doing?
I'm good, thank you, and so?
All good, all good. Thank you very much for joining us.
No problem.
Do you say that a lot? I object.
No.
So you're not that kind of lawyer?
No, one of my friends wanted me to stand up in court and say, you can handle the truth.
I was thinking about that.
But it doesn't work like that.
I was thinking about the movie. So we're right on track. So tell us what it is that you do.
I am a general legal practitioner, so basically my focus, I always joke and say I'm a jack of all trades and master of none. So my background is very focused on litigation. So at RC Smith, I basically focused on the deceased estate administration and commercial drafting, and then also on litigation. So that's basically what I do.
Alright, sounds like a lot. And what made you go into law?
I always think it was my mother, but I don't honestly. I was very set on becoming a vet, and I don't quite know where I changed track.
So your mother was a lawyer?
No.
Okay.
I think she just didn't want me to go all the way to Pretoria to go and study.
Okay, alright. Okay.
So I think I just basically looked at the university prospectus and looked at what looked nice and kind of ended up seeing, oh, I can do law.
Like really?
And then, yes.
My goodness, okay.
So that's kind of, I'm not quite sure how it happened, but that's where I ended up. Yeah.
Okay, alright, it's very impressive. So like when a real estate agent signs what we call an offer to purchase, right?
Yes.
Or a contract between the seller and the buyer, and it is gotten a final grant from the bank, so then we send it to you guys.
Yes, that's
so
right.
What exactly happens in the 2 to 3 month period when the contract is here with you guys?
So quite a lot actually. We usually start with gathering the information from all the parties. So it will include FICA, which you would know is proof of identity and proof of your registered address. Then there's also proof of the status of a person. So if somebody is married, we would want a marriage certificate, we would want the anti-nuptial agreement if it's out of community of property. And then if it's an estate or somebody is acting on behalf of a corporation, it will be all the documents relating to that. Then after we have all the information, they start drafting the transfer documents. That usually takes about 5 days from when we've received the instruction. They draft the documents, obviously contact the parties to come and sign, which will depend on people's schedules. Once the documents have been signed, there's quite a lot of other steps that follow. From our side, to effect the transfer, we need the rates clearance certificate from the City of Cape Town. So what happens is we apply for rates clearance figures. That takes about 3 weeks because the city is a bit slow. Once we get the figures, we get the money from the seller. Usually the seller, unless an agreement provides otherwise, and then they pay over and we pay over to City of Cape Town. The other things we attend to is the certificates of compliance. We usually obtain that from the respective parties who are liable for it. It's also usually the seller. So that would be the plumbers going out to the house and making sure the plumbing is in order. The electrician, if it's applicable, gas, beetle certificates, and also electrical fencing. So those are your certificates of compliance. We liaise with SARS, we make sure that the transfer duty is paid and obtain the transfer duty receipt. So those are the documents we need to be able to submit. Then usually there are other parties involved in a transaction as well. You'll have your bond registration attorneys and your bond cancellation attorneys. So those are 2 other sets of attorneys appointed by the banks to deal respectively with cancellation of the seller's existing bond and registration of the purchaser's bond over the property. So we have to make sure that everybody's in the same page because we all hand in the documents at the same time at the deeds office. So we liaise with those parties to discuss the coming and goings of the finances. So what would usually happen is the bond cancellation attorneys will communicate to us the amount they need to settle the balance of the bond that's still owing, and we have to make sure that the money is going to come in from the bond registration attorneys to say that they will say, okay, the bank has confirmed everything is in order, the monies will be available, and we then issue undertakings based on that to the bond cancellation attorneys. So all of this basically happens behind the scene.
It's a lot.
There are also obviously other issues that are addressed during this time. For example, if the title deed can't be found, we attempt to bring a lost title deed application.
Sorry to break you, but it was my first time experiencing that. I have a transaction where they didn't have the title deed. So like I didn't know that we have advertised on the newspaper for 2 weeks.
Yes.
I didn't know that possible. It was my first time dealing with such a thing.
So there are certain things like that that can cause delays. For example, if your offer to purchase is subject to building plans being provided which were approved by the city. I mean, we've now had a matter where there are no approved building plans. We have to get an architect to come and draw up plans for the property, then submit them to council, have them signed. So there are quite a few things that can, I would say, impact on a matter. It also depends, if the parties are not located close by, the documents have to be sent, to other provinces or overseas to be signed, and then have to come back and go through a process of authentication, to a consulate or somewhere. So that's usually, I would say, where the delays come in, but that's the usual course. Then, as I said, that's just where we actually get to handing in
We're
the
still not
documents.
done.
No. Okay, so then we are at the process now. We've sorted out, everybody's signed, all the supporting documents have been obtained, then we lodge in the deeds office. So once we've lodged that, it's in the hands of the deeds office. So it depends on their turnaround times. At the moment, they've speeded up a little bit. We're looking at 8 to 10 days for them. So in the deeds office, we lodge, then it goes through examination. Then they make notes and see if there's anything that needs attention. If they've got, as I said, at the moment it takes about 8 to 10 working days, then it comes up on what we call prep. So on prep, you can now see what notes were made on your file. Then you have 5 days to resolve those notes. Once within those 5 days, you address it, and then you can hand in for registration. And once you've handed in, the next day it registers. Then the property is now in your name. It's transferred to you.
And that's the day that agents live for. Registration.
Yes.
It's a wonderful day.
When you get your money.
It's a wonderful day. It's a wonderful day.
When you know the money's going to come in.
I'm telling you. When they say the deal is registered, the client might think that I'm happy that they are getting a new property. I'm really not. I'm just happy that my bank's going to be looking good the next day. So,
but it's also exciting because that's when you start handing over keys.
Yes.
Yes.
Mari, I'm more excited about the money, but okay. Okay, it's a lot. It's a lot. I take off my head for you guys. Like you guys go through the most here. So we know a person can sell their property themselves, right, without an agent.
Yes.
But can a person sell their property without a law firm or a lawyer?
No.
And okay, so it's
the short answer is no, because only a conveyancer can attempt to transfer a property in the deeds office. So only a conveyancer. They say it very, very formally. They talk about appearing in front of the registrar of deeds. So only a conveyancer can attend to the transfer. And sale of immovable property is one of the contracts in South Africa that must be in writing. So you can obviously draw up your own contract, but you'll have to make sure that it complies with certain formalities. And for that reason, it would usually be suggested that you have some assistance when you do your offer to purchase, even if you are selling it privately. And then also you will need a conveyancer at the end of the day. It's always the seller's choice who the conveyancer is.
Wonderful. Because, with that question, I had addressed it a few weeks, I think it was 2 weeks ago, when I was driving in the neighborhood, one of the neighbors like hoots, and then he stops me. So then he's like, he's thinking of selling one of his properties, but not the one he lives in, another one. So then he's like, but I don't want to use you guys because I want to get more money. And do I need to use lawyers? And I'm like, yes, you need to use lawyers. But I wasn't sure like if it's a need. But like I told you, he needs to use a lawyer. It's fine that you can't use us, but you definitely need to use a lawyer.
It's one of those things where, although you might spend some money, it can be very expensive if you don't do it correctly.
That's what I told him. He'll regret the money that he'll lose in the process. Alright, so you say you mainly deal with estates.
Yes.
And what is an estate? Can you explain to us?
So estate, just to put it very simply, is the property that you own. So not just immovable property, but We talk about movable properties, for example, if you have shares, if you've got money in the bank, if you've got a nice car that you're driving, or if you've got anything else that you would usually say is of value, that would be your estate. So we deal mainly with deceased estates. That's when somebody has passed away, when they own property, not immovable, but as I said, all movable and immovable property. That is what constitutes an estate. You also get insolvent estates where somebody has been liquidated, or we say there's a dissolution, or where there's a dissolution of marriage and you have to basically then, if you married in community of property, then you also deal with that estate basically. But we do deceased estates.
Okay. Like that was very confusing when I first joined property, because I would hear Ralph speak about like an estate. And when I'm thinking about a posh estate where people live in,
No,
so it was very confusing at first. Like I had to ask him to explain it once, and I got that. So tell us, what is the procedure after someone dies? They have property but no will.
Okay, so it basically follows the same route. If you have property, whether you have a will or not, it's reported to the Master of the High Court. So it sounds very fancy. People always think it's this important person sitting in a fancy office. The Master is actually an office, a whole office full of people. That's just referred to as the Master of the High Court.
It's not someone who's behind the desk who's like an actual master.
No, they do have like a chief master and assistant masters, and it's just say the office we call the Master of the High Court. So they basically attend to all estates. But they also deal particularly with deceased estates, so we report it to them. We will then just report it as an intestate estate. That's what we call it if somebody passes away without a will. The only thing comes in with an intestate estate, there's law determines who gets what. So if you have a will, then you've got the choice of saying, I want my property to go to X, Y, and Z. But if you don't have a will, then the law determines how it devolves. Usually it will devolve, upon if you've got children or a spouse. If you don't have, then it goes to your parents or your brothers. And sisters, that's basically the law just determines in which scenario, where does it go.
No, I got you, understood. And what happens in the case of somebody dying with a will, but the siblings or family are contesting the will? Is there like any situation where people can contest the will and win?
Yes, you can, but you can only, if you want to contest the will, you'll have to go to court, and that's usually quite costly. So it's very seldom that people actually, I want to say, follow through with it. But there are quite a few times or scenarios in which you can actually contest it. So one of the first things is we talk about legal capacity to attest to a will. So capacity would be to say if the person, obviously you think about mental capacity, that would be one, to say the person wasn't of sound mind, they were drunk when they did the will, they didn't know what they were doing, but they will have some difficulty in convincing a court. You would really have to show to the court that the person wasn't aware of what they were doing. Otherwise, also to say that they were, you often get it when people are quite ill, suffering from diseases like dementia or Alzheimer's, where people try and convince them when they're really no longer quite of a sound mind, as I said, to try and change their disposition. So that would be one. Capacity also being to say that you have to be of a certain age, so you have to be over 16 or 16 and older to attest to a will, and then also you'll have to say if you're 16, which is quite young, to say that you know and understand what you're doing. So in that sense, capacity can also come in. The other grounds would be formalities. So there are certain formalities. You have to sign it in front of two witnesses, 16 years or older, and they must be in each other's presence and in your presence. So in other words, it would be you and the two witnesses at the same place signing in front of each other. And then also somebody who stands to benefit from your will can sign as a witness. So that would also be grounds. So on those grounds you can go and contest it. Forgery, if somebody forged a signature, or they there was undue influence or something to that effect, you can also then also I think that story about the boy in the Desalta estate who was alleged to have killed his parents.
Oh, yeah.
Henry van Breda, sorry, the name escaped me for a moment. So everybody was talking there about, they talk about it, and I think I want to say the Dutch maxim is the bloedige hand erft niet. So it means like the bloody hand doesn't get or can't inherit. So if you basically were involved in causing the death of the person who you stand to inherit from, then you basically disqualified. So on that basis you could also then contest a will.
Wow, that's
Public policy, that's the last one. So if you say, I say my son Kanya can inherit everything in my estate if he goes and kills my divorced wife, then public policy will kick in and say that's obviously something you can't do. Yes. So it's against public policy, so for that reason it's invalid.
Alright.
So that would be some of the grounds on which you would be able to contest.
Alright, no, I got you. You don't have to mention names for this one, of course. But tell us about like the toughest clients situation you have been in. Some deal that you wish you can forget.
I think it's usually divorce matters. We had this one very crazy Greek lady. She just drove me up the wall. I think she really got she was quite well off, and it was very difficult to try and, I want to say, pursue her case for maintenance and things when she wasn't necessarily
needing that money.
Well, needing it on the one hand, and also, I don't think she was extremely entitled, and it was very difficult. She didn't want to understand when you tried to explain to her the legal, and she kept wanting matters to be advanced, and then once you did it and it didn't go away, she would turn around and hold you accountable, even though you might have explained the consequences. It was just a terrible situation.
Something you wish you would forget.
Yes, it never happened.
Okay, got you. Now tell us about the best deal or client situation you're ever in. Something you think about and smile. Something you'll tell your great grandkids about maybe.
I think it's usually things where you eventually came out on top, where you struggled in the beginning, and then there's two things. I prosecuted for a little bit. And I went straight from varsity to prosecuting, and sometimes the attorneys would come in with their bags full of their books, and they would stack them on the table and look
I've seen that in movies. They do it really?
Yes, they do. It's like an intimidation, and we we had this one matter where they were basically contesting that the search and seizure of crayfish and other marine products was done lawfully, and we had to and they brought this interim application, and it was to be heard and argued, and we had to submit written heads of arguments, and that's something I never did at the time. We just used to stand in court and waffle on. So I had to go prepare, and I went research case law and everything, and I put everything together, and I actually won, and I was so chuffed.
It was a proud moment.
Yes, very proud. So I was very chuffed about that.
I got you.
And the other thing was just this very old man whose property was subject to a land claim, and he was willing to come to the party and settle, but the matter just couldn't get resolved. It had to be go through the land claims court, and that was also something that was sitting on a lot of people's desks, that finally kind of dug into it and got the relevant people on board, and we finally could sort it out. It was just very nice to see how happy this old one was to finally get some rest for his soul.
I hear you.
So that was also really nice.
Alright, okay, that's wonderful. Last question. If you weren't a lawyer, what would you be?
Probably something in the sciences. Yes. I don't know if I'd still become a vet. Probably like a lab tech or something like that.
Okay, got you. Mari Botma, thank you very much for joining us.
Yeah, thank you.
You have a good one, alright?
Yeah, you too.
Thanks.